Welcome back. As you know, there have been some disputed constituencies where the results have been in a struggle. There's been debates. Some of them declared, but the EC says declared under duress. The officials declared the results under duress. The EC says the officials did the declaration, some of them at gun or knife points. Some, the EC says, they were done in non-compliance with the CI 127, the Public Elections Regulations 2020. To that effect, the EC annulled them and began a re-collation and a declaration. It's been sharing with us precedents to that effect beyond 2020 when it denied the NDC a similar opportunity. So Saturday, last week, 9 of the contested constituencies where re-collation began for them on the back of a high court ruling the day before. 7 out of the 9 were re-collated and declared, all in favor of the NPP. There was such a tsunami, an overturning of all those results. 2 were left outstanding because there were issues pending resolution. That appears to have been ready to be resolved today. But the Supreme Court yesterday, on an application by the NDC for a certiorari to quash the orders of the High Court, heard them and quash the declarations or re-collations for 4 of the constituencies. The parties must go back to the High Court, differently constituted, this time not the same judge, for the NDC to be heard, because, as the Supreme Court heard, they were denied the opportunity to be heard before the judge could give his decision. A number of issues come up. We'll answer them for you. What happens to the already declared constituencies that now are at stake? But let's go to the Supreme Court first for the ruling, unanimous by the 5-member panel.
In the processes before us, the 1st to 7th interested parties contend that the collation of results was not completed in those constituencies. It was in this state of affairs that the 2nd to 7th interested parties filed series of applications in the High Court and prayed for orders of mandamus against the Electoral Commission, which is the first interested party herein. Their prayers were for the High Court to order the Electoral Commission to undertake collation of in their constituencies and to make a declaration of the winner of the constituency election. In the meantime, the applicants herein had earlier on 16 December 2024 filed an application for judicial review against the Electoral Commission, in their case praying for declarations that there had been earlier declarations in their respective constituencies and praying for injunction to restrain the Electoral Commission from doing another collation. On 20th December 2024, the 2 applications were listed before the trial High Court judge for hearing. The first application called by the trial judge was that for mandamus by the interested parties herein. The Electoral Commission did not file an affidavit in opposition and stated in court that they were not opposed to the application for mandamus. However, Mr. Godwin Ebiji Tamaklo of counsel for the applicants hearing stood up in court and informed the High Court judge that his clients were interested in the mandamus application and that they had even filed a motion to be allowed to join the mandamus case. the judge decided to proceed with the determination of the mandamus application and granted all of them in favor of the applicants therein. It is those rulings dated 20th December 2024 that the applicants have invited this court to quash and to prohibit the trial judge from having anything to do with the applications. The grounds of the applications were as follows. I've listed them in accordance with the motion paper. The interested parties filed affidavits in opposition with exhibits as well as statements of case in which they argued in answer to the case of the applicants. Before the courts could hear the application, counsel for the second to seventh interested party raised a preliminary objection and pointed out that the rules require that at the filing of the application for certiorari, the ruling which is sought to be quashed should be attached, but that was not done. The court indicated that the application should proceed and that in the final ruling would answer the charge. Our conclusion was informed by the fact that there was an explanation in the affidavit as to why the ruling was not attached. And we took note of the fact that now the rulings are before the court, and in order to determine the merits of the applications, which have been well argued by both sides, it was in the interest of justice to proceed. So we proceeded. Counsel for the applicants first stated that since at the hearing on 20th December 2024, the trial judge was notified that the suit be affected by the proceedings for mandamus, the judge ought to have joined them to the case in order that they could file affidavit in opposition to the grant of the mandamus. He further submitted that since their application filed on 16 December 2024 was listed before the judge for hearing the same day, the judge had knowledge of their contention that collation had already been completed and declarations made in 4 of the constituencies. So he ought to have permitted them to put that evidence before him in respect of the mandamus application. Now, additionally, the applicant stated that the procedure rules on judicial review in the High Court, which were applicable in the case of the application for mandamus, being Order 55 of the High Court Civil Procedure Rule CR 47, made ample provisions for interested parties to be added to an application for judicial review, but the trial judge failed to apply these provisions and to add them. Counsel for the applicants relied on a number of decided cases, especially Republic versus High Court Bolgatanga, ex parte Hawa Yakubu, 2001-2002, Supreme Court of Ghana law reports. Counsel for the applicants further stated that the trial judge exhibited bias against the applicants by not only failing to admit them into the mandamus application, but by opting to hear the mandamus application first when their application for declarations and injunctions was filed earlier in time. In answer, lawyer for the first interested party relied on the statement of case he filed and added that he observed that none of the individual parliamentary contestants had an affidavit before the court in which they complained about any miscarriage of justice. Lawyer for the second interested party, the second to seventh interested parties, stated that he was vehemently opposed to the application. He pointed out that the applicants built their case on the failure of the trial judge to join them to the mandamus application. But he submitted that the rules of the court on non-joinder of a party is to the effect that non-joinder does not vitiate proceedings. He referred the court to the case of Bobier versus 21st Century Company Limited. He submits that the judge had a discretion given to him in the application for judicial review to join interested parties if it was in his opinion. If it was in his opinion that they would be affected by the proceedings. The trial judge did not consider the applicants necessary parties and he exercised his discretion against joining them. He submits that such order would not be granted to quash the exercise of discretion by a trial judge. He referred to the case of Republic versus High Court, the Republic versus Court of Appeal, ex parte Chatichikata, 2005-2006 Supreme Court of Ghana Law Reports. Now, the consideration. In our opinion, the crux of this application is whether, under the circumstances that the trial judge was faced with, could he have proceeded to determine the mandamus applications with adhering the applicants in the form of affidavit evidence and legal submissions on whether the case before him, notwithstanding non-opposition by the Electoral Commission, was a proper case for the grant of an order of mandamus. It is very clear to us that it was plain to the trial judge that the clients of Mr. Godwin Edwidge Temaklo stood to be affected by the proceedings in the mandamus application. And the least he could have done was to grant them a hearing on the facts and the law upon which the application was brought. Our courts and all courts, especially in the common law tradition, have held this right to a hearing so sacrosanct that under the circumstances of this case, the applicant ought to have been given a hearing, notwithstanding or irrespective of the provisions of Order 4, Rule 5 of CI 47 on joinder generally and Order 55 on judicial review. In the case of Awuni versus West Africa Exams Council 2003-2004, Supreme Court of Ghana Law Report, the Supreme Court quashed a decision of an administrative body, that is the West Africa Examination Council, for failure to accord persons a right to a hearing. The statute under which the West Africa Examination Council functioned did not expressly confer a right to a hearing, but the Supreme Court held that the West Africa Examination Council ought to have accorded those affected a right, since the right to a hearing had been elevated to a constitutional right in Article 23. If that had been held to bind administrative bodies, how much more a court of law? In the case of ex parte Hawa Yakubu, the High Court in Bolgatanga made orders in an election matter which affected Hawa Yakubu, a candidate at the election. And though she was a non-party, the Supreme Court held that on the facts in the case, the High Court violated her right to be heard and quashed the orders of the High Court. The interested parties say that because Mr. Godwin Edwidge Temaklo was allowed by the trial judge to speak, he was accorded a hearing. But they must realize that he was allowed to speak as a friend of the court, as recorded by the judge himself, and not as counsel for the applicants. This is an unfortunate misunderstanding of what amounts to a hearing in the mandamus application of this nature. Hearing plainly required the applicants to have filed an affidavit in the matter and to have made legal submissions. In this case, none of that happened, so the trial judge violated the right to a hearing of the applicants. Now to our orders. We have taken note of the fact that the applicants did not contend that there had been earlier completed collations in respect of Nsawam Aduajiri and Ahafano North constituencies per paragraph 8 of the affidavit sworn to by Fifi Fiabi Kwete dated 16 December in support of the motion for judicial review filed by the applicants on 16 December 2024. Since the orders which have been brought to be quashed are separate and distinct, we have decided to exercise our discretionary power to quash by certiorari, having regard to the peculiar circumstances of each ruling. Consequently, we hereby quash the orders of mandamus made for collation of results by the Electoral Commission in the following constituencies: 1. Okaikwe Central. 2. Ablekuma North. 3. Tema Central. And 4. Techiman South. Accordingly, the collation of results in the above constituencies by the Electoral Commission after 20th December 2024 on the orders of the court are hereby set aside. For the avoidance of doubt, the orders of the High Court made in respect of Nsawam Aduajiri and Hafano North are not affected by this order, by this our order, and in effect those declarations stand. Despite quashing the orders stated above, the applications for mandamus themselves are still alive and ought to be heard and determined. In line with our those which have been quashed, to file those which have been quashed as interested parties. The time for filing is hereby abridged to 2 days from today. The applicants for mandamus in the High Court upon service may respond to the processes of the interested parties. Having regard to the circumstance of time constraint on the national electoral calendar, we hereby abridge the time for a hearing of the mandamus applications in the High Court and direct the High Court to hear the applications for mandamus on Tuesday, 31st December 2024. I hope Tuesday is 31st. On the issue of bias, we are not satisfied that sufficient evidence has been provided to us by the applicants. Nevertheless, in order to maintain the integrity of the adjudicatory process and in line with the practice of this court in cases such as Republic versus High Court ex parte, Agua Company Limited, Auditor General Interested Party, 2019-2020 Supreme Court Law Report of Ghana, Adare, we hereby direct that the applications for mandamus that are extant shall be placed before a different High Court judge for hearing and determination. To conclude, by the conclusions reached in this decision, release A1, A2, A4, and A5 endorsed on the applicant's motion paper are hereby granted, while release A3 and A6 are refused. Release B and C are hereby dismissed.
And that's the Supreme Court's issuing quashing orders by manner of speaking in law, certiorari, against 4 of the constituencies where the orders of mandamus were obtained from the High Court and compelling the Electoral Commission to conduct the collations, re-collations, and declarations in those constituencies. So 4 of them quashed. As we understood, we will find out the implications now. On Saturday, this application before the Supreme Court was pending, and a stay of execution had also been filed and served first on the police. So the police were not supposed to have provided security for the re-collation or collation that happened on Saturday, but they did. What happens? What's the consequence for that? As you can also see, the Electoral Commission had filed an affidavit in opposition and statement of case in the same matter that was pending, and for which there was a stay of execution application as well. And the Electoral Commission went ahead with gazetting of the constituencies as they spoke to the press yesterday, while the Supreme Court processes were underway, that they had gone ahead to do gazetting. What does that mean? And are there any implications? Because there's already been a gazetting of those 4, will they stand, or what will happen? A new judge has to hear the mandamus application by offering the NDC the opportunity to be heard. And as you saw on your screens, the panel of 5 was led by Justice Gabriel Scott Poimang, and you had the other 4 members, Her Ladyship Justice Professor Henrietta Joy Abena-Mensah Bonsu. You also had Justice Ernest Yao Jeu, you had Justice Henry Kofi, and Justice Richard Ejay Frimpong. That was a unanimous decision. Now, let me introduce you to my guest here in the studio, and also joining us via Zoom in the studio, Clara Kwalaga Berry Kasati is Chairperson, Constitution Review Consultative Committee, that is the CRCC, who have just submitted their report to the President of the Republic, led by Osei Mensah Bonsu, who had oversight over this process. The President promised that he will hand over the report to John Dramani Mahama with notes on what he thinks about the report, but he insisted that there ought to be broad, nationwide consultations to complete the process, and if as it were, the amendments will happen, that must first happen before any constitutional amendment. Now remember that this is the committee that informed you earlier that they had proposed that ministers should be capped at 25. They also asked that the deputy minister should completely be, scrapped. And then the regional minister's office should also be scrapped completely. There are other interesting matters that they raise. Oliver Bakavomowo joined us last week. He's back. He made a post about the heavy, as it were, burden and good opportunity handed John Dramani Mahama to do a host of things for the people of Ghana by the parliamentary majority, or call it super majority, that they appear to be getting. And that went viral. He will be telling us constitutional processes, what he thinks must happen. He's Constitutional Rights and Policy Strategy Advisor of the Democracy Hub. He was with the Constitution Review Commission set up in 2010 by Professor John Evans at Atta Mills. He played a pivotal role in that. Here in the studio is the Honorable Inus Afuseni, former MP, Tamale Central. He was Ranking Member, Constitutional, Legal and Parliamentary Affairs Committee of Parliament of Ghana. He has been Minister in 2 different portfolios. Of course, this process of the CRCC, Constitution Review Consultative Committee process, he has also been played a part in it. Ayikwe Otu is former Attorney General and Minister for Justice. He's a leading member of the New Patriotic Party. And then later, Osei Mensah Bonsu, MP for Suhum Immediate Parts, Majority Leader, Leader of the House, and Minister of State with executive oversight of the CRCC, Minister of State with executive oversight of Ghana AIDS Commission, Minister of State responsible for presidential affairs, and Leader Emeritus. Recently, you heard them in Parliament calling him the Supreme Leader, and that's a new title. But Charlie, the titles in this republic. Anyway, so he'll be joining us later and to tell us why this government embarked on this process on the back of the Constitution Review Commission set up by Professor John Evans Atta Mills. Ladies and gentlemen, good morning and welcome to Newsfile.
Good morning, Samson.
Great. So if I may begin with Oliver. Oliver, yeah, last week you said you found no problem at all with what Justice, Reverend Father Justice, I don't know how to put all of that together, Joseph Ajiman had done by giving the mandamus orders to the Electoral Commission that led to the re-collation or collation of the 7 out of the 9 constituencies that were outstanding. You said you found absolutely nothing wrong with it. What do you say?
I think that the conversation we're having went to the substance of whether or not the EC had authority and power to re-collate elections. And my view and consistent position is that once you've been given the job to collate, that job does not end by the first declaration of results. And that if you have reason to revise that, you're entitled to do that. Now, in the conversation we are having, and particularly in light of the Supreme Court decision, we ought to distinguish between what is doing the right thing rightly and doing the right thing wrongly, meaning that there's a procedural question which is at the heart of the conversations here, and which the Supreme Court, I believe, was absolutely correct in directing in the orders that they are taking on this matter, which is that the substance on how the judge may reach the decision to order mandamus may not change, but what is sacrosanct in our democracy is the right to hearing. That persons who are entitled to be heard on the matter ought to have been given the audience to speak to this, which is what we are denied them from doing. And in fact, from the proceedings in the Supreme Court, and the extent to which the High Court judge took to ignore matters that had been brought before his attention and were pending before him, I think that very few people would have been supportive of his decision to refuse the NDC the opportunity to be heard in the matter. Now, one of the things that we can agree the Supreme Court has done is, I believe, is a Solomonic judgment. It's a judgment that, for lack of a better word, favors our democracy and enhances the rule of law. It's the direction of a lot of people have been hoping to see from the Supreme Court in years. And I think that everybody will be overjoyed in the way in which it brought clarity and maturity to the decisions that it made. But it doesn't resolve the issue, and I don't think the Supreme Court intended to. It recognized the authority of the High Court to make those decisions and do it so rightly. And so we are back to the drawing board, in essence, that the NDC will get an opportunity to be heard of the matter. But there's something important here, which for even you and I who are interested in the legal question as to whether the Electoral Commission has the legal authority to re-collate, that this may not necessarily resolve, because of the manner in which the court has been approached. The court has been approached on a mandamus application. And the mandamus requires that you make a showing that the Electoral Commission has either failed to collate or is refusing, after a reasonable demand has been made on it or after a reasonable time, to collate. It is surprising to me that in the High Court proceedings, the EC, even though it has not said anywhere that it is refusing to collate, went ahead and did not oppose that point. So when we come back before the High Court, that question is going to arise again, and I think the NDC is going to be happy on that, which is that there's nowhere where the EC has said it is refusing or failing to do a statutory duty. And if there's no failure to, and there's no refusal to, then a mandamus does not lie in terms of how law operates. Now, there's a bigger question as well centrally to this, which is the Commission's persistent recourse to placing the judiciary before a fait accompli, which for me is a strategy that seeks to undermine judicial oversight by putting in place what it considers to be reversible outcomes. And I'm speaking here, one, when there was a state of execution, it went ahead to collate those results. And the last week we talked about, we don't understand the rush. A rush which is not only just a rush, but is also offense law and procedure, which is that you cannot disrespect the courts when there's a pending application to stay. You can't take any actions. Secondly, and as you have pointed out in the beginning, the fact that the EC participated in the process, filed an affidavit in opposition, and yet went ahead to gazette those results. Again, another attempt to place the court before a fait accompli. This series of actions, for me, is something that we need to look at. The liberty with which the Electoral Commission continues to give itself in undermining the judicial process is really concerning, particularly when consistently trust in it is low and when people are continuing to call into question his actions. What happens next as to those series of actions, I don't know. But one thing we are clear about in law, and perhaps here we have sort of an extension of the grown norm principle, that the chain of legal validity of those declared results and then consequently the Gazette has been broken. The Supreme Court has quashed those, which means that the Gazette which is based on those declarations are null and void and have no legal effect. That ought the position of them. And I know a number of people have suggested that the EC can go ahead and submit those Gazettes to Parliament, and Parliament ought to respect it. I don't think that is going to happen unless, obviously, we see what happens in court.
There are those who actually suggest that the NPP could simply withdraw this mandamus application so that on Tuesday there will not be any application to be moved because those results have already been gazetted.
And I've heard that view before, and I think that, in fact, I have made that suggestion that that possibly could happen, where the NPP could withdraw the application. But the fact of withdrawing the application does not nullify or extinguish the Supreme Court's order that the declarations were null and void. So those declarations that were made on Saturday in particular do not exist in law. The question is whether or not, and then we get back to the same point we have been going back and forth on, whether the EC is entitled to go back and recollate, whether with or without a court order. That question continues to remain alive, but for all intents and purposes, all we have now is the earlier offense declarations, which have not been nullified by any court process, but unfortunately do not have the benefit of a gazette. And in that situation, it will be interesting to see how we navigate if the MPP decides to withdraw them.
So imagine the MPP went ahead to withdraw its suit, and therefore on Tuesday there will not be suit to be debating. Is the EC under some compulsion to, as it were, gazette the 4 constituencies for which the mandamus order for the coalition have been quashed, so that those people, once they are gazetted, they go into the House on the 7th and they are sworn in, those who are aggrieved would then, pursuant to sections 19 and 20 of the Representation of the People law, proceed with a petition to the High Court?
The EC could take that approach. Unfortunately, if it does that, it means that it will be going against its own position consistently, which is that it believes that those declarations were illegal and unlawful. So that would place the EC in a peculiar position where it would then be proceeding to gazette actions that the Commission itself has declared unlawful. Now, we have to be clear that the orders the Supreme Court has made have no effect on whether or not, or does not resolve the question of whether or not the EC can proceed to do a re-collation and redeclaration without any court orders. It doesn't answer that question for us. And it seems to me that to be consistent with its position that those declarations were unlawful, that it might proceed to say that we are going to do new re-collations which do not owe to or do not derive from the impugned High Court orders, which is what's likely to happen.
Okay. I heard you bring up a new thing. I don't see how that does not contradict your position on Saturday. You are saying that a mandamus primarily will only lie if one has refused to perform their official duty. Today you are saying that there is no evidence that the EC has refused to perform its official duty. Therefore, the mandamus application was premature in the first place.
Now, if the party which is the respondent which has the legal duty in respect of the mandamus application was the EC, the EC before the High Court judge invariably admitted that it had failed to or was refusing to perform that duty, which assertion we know was incorrect at the time. And this raises another specter which I think Edu hammed on in the Supreme Court, the risk of pollution. That if you have, it essentially becomes a fixed match. But our legal systems abhors this. That's why we have an adversarial system. And if you have an adversary, which is in fact not a proper adversary, like the EC is doing, that raises question and why it heightens the need for a third-party voice to be admitted into the conversation.
All right.
Now, if the NDC comes into the process, the concession that it has not done that obviously does not hold, because we have proved that, in fact, declarations have been done, and so the duty had not been not performed, or that it was not refusing to do that. And I think that's the situation in which we are.
Right. Let me get to Yunus of Seni before. So, what do you make? Is the issue resolved? What do you make of what has happened? And can you answer the question if the issue is resolved as we speak?
Well, I think first of all, let me say good morning to Clarity. Sometimes since we met at Kwabinya or where?
Yeah.
Yeah. And to my good friend Samson. Indeed, Samson, the issue has not been resolved. It could not have been resolved. Now, because if you look at the electoral laws of this country, it seems the Electoral Commission has led us into a situation where we are now struggling as a country to extricate ourselves. Now, if you look at CI 127, and I've read your comment, it appears to me that there ought not to have been any rush at all into recollating the results of the disputed constituencies. Because the law, the CI, which is a CI of the Electoral Commission, clearly details steps that an aggrieved candidate in an election must take and how his rights accrues. That is after the results of the election in that particular constituency has been gazetted. Now tell me, Samson, all this hula baloo about mandamus compelling the Electoral Commission to perform a duty that is imposed on it by law, which the Electoral Commission has refused to perform, or collating the results of an election, which of them could not have been achieved if we had simply waited for the results to be gazetted and the aggrieved party takes the matter to court? Which of it could not have been resolved? Now, we have been put into a constitutional crisis today because the EC appears to be the interested party in this case. And I've said when we were in Parliament in 2020, when the Electoral Commission appeared to answer questions on SAL, that it appeared to me then, and has since been confirmed by many people, that the Electoral Commission was acting as if they were a law unto themselves. Now, just take the CEI 127. Even if there's a dispute where there is equality of votes, and there's a dispute as to whether or not one vote should be counted for either of parties with the equality of votes, it is not within the preserve of the Electoral Commission to determine that one vote. It has to go to the High Court for the court to so determine. So clearly, and I've read the presser of the EC addressed by Bosman Asari. And he says, look, there was an illegality. There was an unlawful act. And we, the Electoral Commission, cannot allow that illegality or unlawful act to stand. What does it tell you?
The EC chair herself had said that earlier, that the processes in those disputed constituencies did not comply with CI 127. To that extent, they had annulled them. They were going ahead to do a re-collation, and because they can't accept them.
So the EC chair says the processes did not comply. Who determines whether the processes have complied with CI 127? Is the EC? You think that is the EC decides that?
Why not?
No, they are not. Another party, another institution of state must so determine whether or not the EC, the processes at the polling station or the constituencies or the coalition center has complied with CI 127. Now, EC arrogating to themselves the power to so determine is what has led us to this crisis, and reinforces the perception of bias of the EC, because people are wondering why the EC all of a sudden can take so much interest in a case in which they, EC, have not alleged duress in court. They, the EC, somebody who was a party to the election, went and alleged in court that somebody or some group of people put an officer of the EC under duress, and that's why he or she failed or declared the results otherwise. The EC did not go to court.
The EC was in court and said it was not opposed to or did not disagree with these claims. Hold your thoughts there. We'll take a quick break. We'll return so that our radio audience will get the opportunity of joining us. As you know, we began at 8 o'clock, not the normal time that you have been used to Newsfile. This is the third time that we are doing so. We'll continue in this direction to give you more time, particularly during this transition era. We'll be right back. This is Newsfile. It's your most authoritative news analysis platform, and this is your election headquarters. During the period of the transition, we're giving you extra, and hopefully thereafter. Show is brought to you by the candid sponsorship of Bank of Africa, as strong as a group and close as a partner, MTN, everywhere you go. Ashesi University, educating ethical and entrepreneurial leaders for Africa. Robert & Sons Optical Services, your comprehensive eye care service provider for 33 plus years. My Way Insurance, simply dial *165# on MTN to join My Way today. DB Industries, roofing Papa Fie. Flamingo Paints, simply superior. Syntex stands, it's strong, it's tough. And Activa International Insurance. Our clients are passion. And if you're just joining us, my guests, Clara Kasati, Oliver Bakavomawo, Inusa Fuseni, Ayikwe Otu, and Oseche Mensabonsu joins us later. And so far you have heard Oliver Bakavomawo. We have heard from the Supreme Court, the full decision yesterday that quashed 4 of the recollated results of the constituencies and only preserved 2 of them. That is in Sawoma Drejiri and Ahafwano North. Because the court said there were no complaints about that they had been recollating. It was just a process that had not been completed. So the EC should go ahead and complete. Oliver, it's clear that agrees with the Supreme Court that what their verdict is sound. The judge ought to have heard the NDC before proceeding with its decision on that day. He was in court on that day. And he points out that, in fact, the principle, the basic common thing that allows for a mandamus order to be issued, as the High Court did, is that there must be a factual basis to the effect that the EC had refused to perform its official function. And there's no evidence that the EC had refused to perform its official function. Remember that the EC had told us that week that the police was refusing to give it security on the basis that it could not assure the safety of the process. So he says, on that basis alone, it looks like going forward, there's trouble. There's a new High Court judge that will be appointed to hear the matters. Inusaf Hussaini insists that the EC had no role at all once there were collations and the declarations had been done. The EC has brought trouble upon itself unnecessarily. But here you were at a point where, so what happens that the EC finds that in some constituencies, at least 2 of them or so, the results purportedly declared did not contain the full polling stations being brought together. So one place there were 2 or 3 polling stations left out. One place there were in so many dozens of polling stations left out before the declaration. You are saying the EC still should have overlooked this and gone ahead to Gazette and let the aggrieved party go to the High Court to fight it?
That is why the Supreme Court has said that they are not minded to interfere into what happened in the in Sawan Eduajiri and W. Kwabenya.
Hafuano
North. Because to my mind, the collation process was still ongoing. And I've heard people cite the case of Tolong, the case of Zabzugo Tatali, the case of Pru. This is exactly what happened in those constituencies. Collation of results through the pink sheets of the various designated polling stations had not been completed. In fact, in the case of Zabzugo, the place was becoming very unsafe for the electoral officers. And so the ballot box, the whole process was moved to the regional office in Tamale. In the case of Tolong, where Abdul Razak became the first NDC MP after Salifu Abdullah, Honorable Salifu Abdullah, the wind, there was no way the collation was going to happen in Tolong. In fact, the ballot papers, the ballot papers, including the pink sheets, inserted into the ballot boxes were destroyed. So they moved the process of collation from Tolong to Tamale and asked the contestants, the various candidates in the election, to produce their pink sheets. And when they produced the pink sheets, they matched them and verified the authenticity of those pink sheets and collated the results in Tamale. This is significantly different.
And this was in 2004.
It's significantly different from what has happened. Indeed, journalists were at the various polling stations, and no journalist reported that a presiding officer of the Electoral Commission at the at the collation centers that are now the subject matter of these disputed elections was under attack. No journalist reported that. And police officers were assigned to those collation centers. And we've not heard the police say that they were overpowered by a marauding group of people, and that put fear in them, and so they also abandoned their duty, their post. We have not heard that report. And the rules, CIF 2127 says that if your agents, you assign agents to the collation centers, or yourself, you're present at the collation center, or your representatives, if in the event that the results are going to be declared and you abandon the collation center, that should not operate to stop a declaration being made. And so the laws are so clear that I don't think that the court, the High Court, and that's my view, the High Court should have entertained this matter, because there were so many remedies available to the losing candidates to pursue after the declaration of the results. And for me, I think that we should be very careful the path we are treading. And the last question that Oliver Bakavomawo asked is very relevant to these discussions that we're having. He asks whether the EC can recollate results without a court order. Can they? It's my view that they cannot do that. In fact, I even extended to 2020. You remember, I made a lot of comments on the EC changing the results of, the presidential elections 5 times. I simply asked whether the EC could do that without a court order. And today, Oliver is asking the same question. Now,
and the court said what? The EC could do that.
The court even didn't entertain the EC. The court didn't even entertain the EC.
What do you mean by that? The case was concluded.
The case was, the matter never came up. The matter,
that didn't go into the box.
Yes, but the court never pronounced on whether or not the EC can declare results and change the results 5 times. And Samson, this matter is very important for our democracy, for our country, the cohesion of our country. In fact, it is only by God's grace that the people of this country are peace-loving. And they have elected democracy as a form of government over any other government. The conduct of the EC, which is highly incompetent, could throw this country into a mess. And the people, people could rise up against the EC and this country would be in flames. Because even with the 7 constituencies, can you imagine what the conduct of the EC could do in these 7 constituencies? Now, it has been said time and again, and particularly for Boss Manasari, that he's repeatedly said, first he said on radio that the NDC was a veritable threat to our democracy. As recently as November this year, he's reported to have told somebody that the Electoral Commission cannot hand over power to cannot allow the NDC to win the elections.
Really?
Really, yes. In fact, and the person he told that was alarmed.
I don't think this is fair.
No,
what we know about was what is on record, which the statement he made on April 26, 2019, as reported that NDC's posture a threat to Ghana's democracy. And this is what he said. I want to read it because this comes up often and we don't go to the specific statement, and sometimes he himself denies it, even though this is what he said. So he said, quote, "I think if there is anyone who is becoming a threat or a potential threat to the democracy we are practicing in our country, then I would rather say that it is the posture of the NDC. Since this new commission took over, we have noticed some of the things that have transpired. Before the Ayawaso West by-election, allegations were rife that the register was bloated, and we also noticed pictures of bloated papers. So we as a commission, we have seen a particular pattern of the NDC. So I don't see why the NDC will turn around and accuse the chairperson that her actions were a threat to democracy. This is the only commission that is committed to Ghana's democracy because we are operating within the law."
How can they operate within the law? Which law? Their law? Their law, which is in their hearts? Or the laws establishing the Electoral Commission and the various EI promulgated pursuant to the Constitution? Because we don't see what they are doing founded in the laws. We don't see that. And so, let me state that what I have said, Samson, is a matter that can be pursued, and that will be pursued. Because the person to whom he said that to is alive. And the person was shocked that a member of the EC could openly declare that the NDC must not win the 2024 elections. And that person is willing and able, anytime that this matter comes out for investigation, to appear before any committee or commission.
Right, so I will be going to the judgment of the Supreme Court in 2021 about whether or not the EC can correct errors or mistakes. There are those who argue that you cannot say doing a recollation is intended for a correction, an administrative purpose. And the lawyers for the NDC who were in court insist on that it is not something you can call a correction being done. So I'll reserve Clara for the attitude she will bring to this. Let's go to Ni Ama Ayikwe Otu, former Attorney General. Thank you very much, sir, for joining us. What do you make of the Supreme Court's decision yesterday? Please unmute your mic.
Okay, thank you. Yeah, I have done that.
Great. We can hear you now.
Can you hear me now?
Clearly, sir.
Yeah, thank you. Thank you for having me. Well, the Supreme Court dealt with procedural matters. I had made the point that one of the grounds of quashing decisions is the breach of the rules of natural justice. And it's a very strong ground anytime it is used.
That's right.
I do recall when I did the case for Dr. Pakwesi Indum when he was disqualified. It was one of the grounds I used, and he prevailed. So immediately I saw this one, I said to myself, wow, what is happening to this judge? Because if you don't give them a hearing, they will rush to the Supreme Court and tell the whole world that they were denied their right to be heard, which is also a breach of the rules of natural justice, and your ruling would just not stand. Again, I even have a difficulty with the MPP lawyers who went to court, because we all know that they are interested parties in the matter. Usually, when you have a title, the Republic versus so and so, ex parte, the applicants, then you add what we call the interested parties. So if clearly there were interested parties, why did you leave them out? Again, when the guys went to court to say that, look, although we've not been served, we've heard of what is happening. So we have applied to be joined to the action. The judge did not grant that application. But if you look at the 55 Rule 6.1, the court may, on the hearing of an application for judicial review, allow a person who desires to oppose the application to be heard, notwithstanding that the person has not been served with notice of the application, and may direct that person to file an affidavit. So is the judge saying that he is so unfamiliar with this regulation, especially having regard to the fact that the right to be heard is so sanctified, so held sacrosanct, that if you breach it, you are going to run into difficulty. So all that the Supreme Court has done, in my view, is to say that because the people were not giving any hearing, well, we are going to quash the decision you make, but then the mandamus is still alive, and you can go back to continue with your hearing. At this stage, that the NDC will now be, or the affected parties will now be given the right to be heard by filing their necessary affidavits. They've been given 2 days to file, whatever it is, for the others to also respond, and they have breached time for the hearing by 31st. So the Supreme Court did not decide on the merits. The thing with the Nsawam Ajiri and Afuano is a little problematic, in a sense that what they are saying is that the thing took place and it was concluded. So that ends the matter. But it seems to me that the main point they were trying to make is that there was no objection from the NDC itself on those two main issues.
That's correct.
They didn't think that anything arises for this kind. So no party really has won anything. You are going to start all over again. If you want me to stop here, fine. Otherwise, I've listened to the rest and I can continue to make more inputs.
Right. So, and let me quickly bring this so that we don't go too far. When the issues of corrected figures for the presidential election came up in 2021 in the Supreme Court held and relying on Article 297 said that where a power is given to a person or authority to do or enforce the doing of an act or a thing, all such powers shall be deemed to also be given as are necessary to enable that person or authority to do or enforce the doing of the act or thing. So to that effect, they held that for the EC to have detected an error and to proceed to correct that error, there was nothing wrong with it. It has also been argued on behalf of the petitioner that the chairperson of the first respondent could not have on her own corrected the error she made without consulting the stakeholders of the 2020 presidential election. The court said no statute or regulation was cited to us by counsel for the petitioner for this submission, and our collective industry has not revealed any. This submission does not find favor with the court in view of Article 297 of the Constitution.
The implied powers.
So the court held that what happened was an error, and the EC can correct an error. Now, so the matter that is coming up now is that what do you make of the point that first you fault the lawyers for not having themselves included the NDC or the affected parties before the High Court? But yes, what do you make of the claim that the EC had not refused to perform its official duty, and therefore there cannot be a mandamus because it had not refused?
Well, I disagree with what Oliver is saying. I had the opportunity to handle a matter, the Republic versus the National House of Chiefs, Kumasi, expert in Nila Mensah and others, where there was no prior demand and no refusal, but a mandamus was granted. I made it my prime point in going to the court to have these things quashed. The Supreme Court said no, in view of Article 23, which seems to have imposed a duty on all administrative powers, bodies, to adhere to their own rules. When you do not follow the rules, it gives the person who is affected a right to come to court and to seek redress. So as far as they are concerned, in view of Article 23, even when the person did not request and there was no refusal, what the court did was okay. So I will remind counsel and others to look at that report, Republic versus the National House of Chiefs, Kumasi, expert in Nila Mensah and others, 2011. That is what the Supreme Court said. There's so much a responsibility on you to go according to the rules that or the laws that set you up, and you cannot do what you like and claim that somebody must have to make a request first. That even if no request was made, even if no refusal, you still are under a duty to perform. And so they went ahead and upheld what the High Court judge did.
Mm. We are familiar with the expert Alhaji Collins Dauda case, in which the courts effectively said that in a parliamentary election where the electoral process have been substantively carried out up to the point where a candidate has been declared elected, then, that will be valid and a petition can be brought to challenge that. So do you think in the circumstances, what the Supreme Court has done now, the status quo ante has not returned, so that in these 4 constituencies, these people are duly declared and the EC doesn't have the power to do a recollation?
I do not agree with this issue, whether or not the EC has power to do recollation. I don't agree with those who say the EC has no power. I'm looking at the constitutional provisions as against the CI 127, which is a subsidiary legislation. And looking at Article 45, it reads that the Electoral Commission shall have the following functions. C, to conduct and supervise all public elections and referenda. Now, at the end of Articles, the CI 127, you will find that it is the EC which must gazette the results and forward it to Parliament. We are not talking about any returning officer acting. We all know that the EC has a small number of permanent workers, and that around elections, what we do or what they do is to, employ or recruit a lot of, temporary workers. So this staff cannot be substituted for the EC itself, as if they are those who have the final say on the matter. They are supposed to work under the supervision. Even if you look at the regulations dealing with the returning officer, he works under the supervision of the district election officer. You see, so at the end of the day, everything comes back to the EC. And when you are suing, you don't sue any returning officer. You always sue the EC for something that you think has not been done. These are people who go to assist them. And so, in my view, so long as Article 45C has not been amended, that it is the Electoral Commission that shall, the functions include the conduct and supervision of all public elections, they have every right to look at it. They cannot sit down. We have all said that where there is fraud, it deshays everything. Fraud is not different from dishonesty. We are told that the returning officer can only collect the results from all polling stations. We are being told that in most cases, all the results were not in. Under what circumstances did they declare the results? And you are saying that the EC should look on when it is his duty to organize these elections, and these are people who are only supposed to help. And between me and you, we know that when it comes to the recruitment, there are all sorts of things that take place in the recruitment. And so there are some who are there who are not necessarily going to do the work for Ghana, but to try and assist other people. You know that as a fact. But they cannot sit down and look on when some of these things are happening. Over 31 polling station results have not been collected, and you say somebody has been declared. The circumstances where you allow that is where you are saying that, even if we, in view of the unassailable, lead that the person has, even if you add all those that we have not counted, it will still not make any difference. So let it go on without it. But you are not talking. You are talking about 31. What we know of MP3, somebody winning with only 3 votes and the rest. And you are saying the EC must accept it. So, I think the Constitution should override the CI 127.
Yes. So the question will be: the court will determine what constitutes an error, for which the constitutional provision you are referring to will apply. The substantive question is this, I think, and that's what is bringing up all of these debates, that you mentioned fraud. Fraud destroys everything. So who determines that there's been fraud? And that fraud destroys the outcome of anything. And what then do you make of the substantive law, the representation of the people law, Section 20, which says that if there is intimidation, if there is non-compliance with law or the regulations concerning the electoral process, that has to be determined by a high court?
Well, I don't know about that, but also remember that under Article 46, the EC should not be directed in the performance of his duties, although that does not immune it from court processes. So where there are court processes, fine, but the independence, in my view, of the NDC, of the EC, gives them that authority to act when they feel something is not being done properly. And I'm still talking about Constitution, not the PNDC law. Okay.
Now, those results that have already been gazetted, and yet the Supreme Court says those have been quashed. what happens? Example where people suggest that the MPP could simply say, well, we are not pursuing the mandamus application in the High Court anymore. After all, these have been gazetted. What do you think? How will it play out?
I don't know what the MPP or those persons affected would gain by saying that they are withdrawing, because there is so much left to be done, and it's only fair that they should go ahead and get the results collated. My brother was talking about Zamsugu. Is it different from what has happened now in Ablekuma North, where the ballot boxes and all the pink sheets or whatever you call them have been bent? Should we go ahead and accept whatever results they have, declared when such things have happened? So please, me, as far as I'm concerned, the Constitution is supreme.
All right.
If what they have gone to, if they did anything wrong, because we all know that when cases are pending in court, you are not to interfere, then of course, what they have done will not wash. And I don't know who advised them to go ahead to do what they did. So I agree with Baka that those things, do not go anywhere. But whoever would advise them to go and withdraw the case in court would rather be doing more harm than good. Okay,
thank you. Now, Clara, so Inusa here says, we didn't see any report of people under duress or intimidation, but we saw a lot of it in some of these constituencies. We saw actually returning officers or officers of the EC making declarations in a manner that was completely absurd. Do you share the view that once the declaration has been done, it's only a third party, the court, that must come in, and the EC cannot be doing what it is doing, as in recollating and doing fresh declarations?
Okay. Thank you very much, Samson, and then good morning to your viewers and listeners and to everyone. Before I answer that question, I would like to break it in 3 parts before I reach my conclusion. The first one is the nature of administrative bodies. So if you look at Article 23, and I'm going to read it because it is very important. Article 23 of the Constitution says that administrative bodies and administrative officials shall act fairly and reasonably and comply with the requirements imposed on them by law. And persons aggrieved by the exercise of such acts and decisions shall have the right to seek redress before a court or other tribunal. What is important for me here is the fact that 2 things, they shall act fairly and reasonably, and then the second one, they must comply with the requirements imposed on them by law. There is no state agency or no state institution in this country that has the right to behave as it likes, irrespective of the law. There is no institution like that in this country. Every institution has an obligation to comply with the requirements that the law imposes on them. So the question then is, what are the requirements of the law imposed on EC when it comes to collation and re-collation? So if you look at the law, I think that's where the answer is. Rather than does the EC feel that something has gone wrong, it is, if the EC feels that something has gone wrong, what does the law require them to do? Because pursuant to Article 23, they must comply with the requirements of the law. Now, the second issue is that the issue is not just that EC simply just wants to recollate. There have been some bases given why the EC wants to recollate. What are those bases? Now, what I read is that there is an allegation that there was duress, there was A, there was B, there was duress, and then
non-compliance.
Non-compliance, and for that reason, this was done. They made the declaration, which is not correct. Now, the EC cannot dismiss that allegation. At the same time, the EC just cannot take that allegation wholesale. Upon the allegation being made, the EC has a duty to act fairly and reasonably. Now, what would fairly and reasonably require them? I think that the persons the allegations have been made against, the EC has an obligation to hear their side of the story before you make a decision. Yes, it is true that fraud vitiates everything, but allegations of fraud do not vitiate anything. It has to be established. So the question, what I didn't see here is how that was established. Because I've always said that as an administrative body, when you make decisions, not everybody will agree with them. But when you treat everybody fairly and you give everybody an opportunity to be heard, they will respect it even if they are not happy. Then at least everyone can see that you tried. So for me here, the issue more is after the allegation has been made, what did the EC do for all parties to feel that the EC was being impartial? There is an allegation. We are not going to dismiss that allegation, but we are going to hear all sides.
Is it necessary to hear all sides where we have footages where we can all see that the coalition centers became chaotic, the NDC asking supporters to, as it were, besiege the coalition centers?
Are those centers, not just other centers?
Soon after that, the NPP also said they can also go there, but they said they should go there and protect the police and the other officers to do their work. I mean, funny.
We see footages. What I want to establish is that the footages relate to this issue that we are dealing with, rather than that we know this happened somewhere else.
The EC has said, we have heard from the EC, the EC says our officers were intimidated to declare under duress, and the processes were not compliant with CI 127. That is why we cannot endorse, these are their words, we cannot endorse the outcome of what they did. We must make sure it complies before we gazette.
Well, so for that, because that particular issue is in court, I wouldn't want to prejudge it as to whether or not the EC should be entitled to that. But what primarily for me, I think, is that you look at the law provides for what should happen and where. Have you complied with that law? As from the discussion, and as we know, there's a mandamus in court. And from the Supreme Court decision, this is exactly what the High Court is supposed to determine, whether or not the EC should go and, in the cases where the claim is that coalition has been done already, whether or not they should redo the coalition, or in cases where it has not been done already, of course, there is not too much of an issue there, apart from the fact that, of course, the issue has been overflogged already. I was curious that there's no affidavit in opposition. So I was wondering, so why are you not doing, if you're not if you're amenable to doing what you're supposed to do, then why are you not doing it? Because I think that people shouldn't need to go through the expense of litigation to do what you have to do, if you know that that is the right thing that you have to do and all of that. Yes, so basically, yes, in short, those are the three issues. But as to a definite answer as to whether or not the EC should be able to recollate in this circumstance, I would reserve that comment.
And why would you reserve that? Because that's not a subject before the court.
But from the mandamus...
The mandamus is to compel it to do its duty, which they say it has refused to do.
Yes, but the Supreme Court noted in its judgment that in some of the constituencies, coalition had been done.
That's right.
And then in
those are the 4 constituencies which the mandamus has been quashed.
Exactly. So, the mandamus has been quashed. So the ones that are alive, does this include those ones, or it doesn't include those?
The ones that were not affected in Sawama, Dredjiri, and Ahafo North, they said those places the process had not completed, and so the EC went to complete them. In any case, the parties in court did not contest those 2 places that there were issues.
Okay. Personally, if you ask my view, I think that there is an issue as to whether the EC has capacity to declare illegality. Is that something within the capacity of the EC to declare that there is an illegality? There's a difference between an error and an illegality. When you say that you have made an error, you admit it's a matter of fact that, oh, I've made this error and all of that. But if you are saying that something is illegal, it's a question of law. And whether or not the EC has the capacity to make that declaration in this case is a question I think the court should answer. And then, of course, yes, so this basically is an issue of capacity. Yeah.
And you will not answer whether they do have that capacity or not?
No, whether they do have that capacity, it depends if the procedure was followed. For me, it's the procedure that is important. If the procedure was followed, due process was followed. Sometimes a dispute might not even arise. Sometimes somebody says, can you do that? I say, yeah, sometimes you can do something. If nobody questions it, it goes. So you could have done, you show the evidence, everybody agrees that this is not well done. Should we do the re-collation? We do the re-collation. But if the issue becomes a situation where there is not consistency, in the past, you say that this is the only circumstance in which we do re-collation, and then in another instance, we say, and you don't demonstrate the difference, you do leave room for people to be dissatisfied.
You're still here on Newsfile. This is your most authoritative news analysis platform. And like Frank Davis did candidly last week on the show, that if there had been service of the stay of execution of the mandamus orders on the police, they ought not have gone there to the EC's regional office to assist the process like they did. You have heard Aikwe Otu, also leading member of the NPP, disagree, that actually deprecates whoever advised the EC to proceed in gazetting the affected constituencies when there was this matter pending, which the EC had actually filed an affidavit and a statement in opposition. And there was actually, in addition to that, there was a stay of execution of the orders of the High Court. It's a long message, but I want to read and pick quick messages to comments to conclude this subject so we can move forward. We'll take a break and then move forward. This one says, please tell my brother Oliver, my brother and friend Oliver, that while not entirely disagreeing with his view that administrative bodies can correct or remedy errors or illegal made by them without recourse to the court, that power cannot be extended to cover instances where there is an allegation of duress or fraud, which has occasioned the alleged illegality. Whether or not there was duress or fraud is a question of fact, and the resolution of this question requires evidence, not mere allegations. Okay, Clara has just been saying this. In this particular case, where the nullification of the earlier results by the EC directly affected those who won, the requirement for evidential hearing to establish the claim of fraud or duress is imperative, and the affected parties ought to have been heard on the allegations, especially since there is no evidence that the alleged duress or fraud emanated from them. To simply say that EC can correct or remedy illegalities brought to its notice by itself without affording affected parties an opportunity to be heard is to give the EC or public institutions like the EC power to possibly collude with whomever to nullify results if they are not comfortable with the outcome by simply sitting in their offices and alleging fraud and duress. That's a serious point. Whether there was fraud, duress, or intimidation is a question of fact and must be proven with evidence. It is not simply a question of mere allegation. So in this particular case, the errors are not merely clerical or blatant breaches of statutory provisions. The EC alleges factual matters, and the evidence is needed to establish these allegations before the results can be nullified or set aside. Okay, so this is from Randolph Chumisi, who appeared for the NDC yesterday as well. And these are, lawyers with views that I think are important to share. And one of them says also that if you refer to the expert Alhaji Collins Dawda case, there is this implication. It is implied that that subsequent processes, namely the endorsement of the writ and its transmission to the Electoral Commission, as well as the publication in the Gazette and notification to the Clerk of Parliament, i.e. the processes in the regulations, are not necessary for the election to be complete. It can also be inferred from expert Alhaji Collins Dawda that in a parliamentary election, the electoral process up to the point that a candidate is declared elected by the Electoral Commission go to the substance of the election, whereas the subsequent processes after such declaration are for purposes of record and public notification and do not affect the substance of the elections. This inference is given credence by CI 15 itself. So, for instance, CI 15 prescribes that publication through some other mass communication media may be substituted for the Gazette publication. Answer JSC in ex parte, Dr. Kofi Asare. Thanks for those. Now, what will be your concluding comments on these and the effect going forward? Let me begin here with Yunus Saini.
Well, my concluding comments are just directly in opposition to what Ni Ayotu said when he just referred to the dry bones of the Constitution in Article 45. To say that because Article 45C gives the Electoral Commission the power to conduct and supervise all public elections and referenda, that overrides CI. Now that's a function of the Electoral Commission. And so Article 50 says that it is mandatory for the Electoral Commission, and let me read it for the benefit of our viewers. And now Article 51, it says the Electoral Commission shall, so mandatory, by constitutional instruments, make regulations for the effective performance of its functions. That is the functions under 45. It's a requirement under this constitution or any other law, and in particular for the registration of voters. You can't say that because the Electoral Commission shall compile the register, they don't promulgate a regulation to show how they are going to do it. That is the essence of the rule of law. That people must know how they intend to exercise their powers under the Constitution. Now, voters, the conduct of public elections and referenda. So it is the Electoral Commission, in exercise of the powers vested in them by the Constitution, and pursuant to Article 51 of the Constitution, that promulgated CI 127. And so you cannot just throw CI 127 under the bus. It derives its authority from the GRUNOM, from the Constitution. And that exercise of power by the Electoral Commission is consistent with Article 45 as spelled out in CI 127.
Your point is?
The point is the Constitution details how that power must be exercised. And that exercise must be in tandem with the law, the Constitution, or any other law. And that is consistent with what we all know, the rule of law. That people must not have unfettered discretion in the exercise of their powers. The boundaries of their powers must be defined by law.
Right. So you understand that the NDC is only going to be heard by the new judge in the High Court. And the new judge could well affirm the decision of the High Court judge that the EC should go ahead, and for those 4 constituencies, there should be a re-collation.
Well, I have described what is happening as a crisis. Because we now have a situation where somebody or some group of people were declared. Now, if they had waited, they would have gone to court to produce evidence clearly showing who won the election and that they won the election. They could have done that with duress or without duress. I mean, for the duress being a matter of fact arising out of common law practice, not by statute. It's common law. Now, so if they even wanted to allege duress, I'm of the view that they could do that together with their pensions to show that the elections were won by them. The second thing is, now they haven't been declared and the results have not having been gazetted, no right was then conferred on the losing parties to go to court to vindicate their right of being declared winners of the election. Now, the Electoral Commission, in their haste to collate, have collated and pronounced, declared that. So there's a second declaration, and has gone ahead to gazette. Now, what happens? The Supreme Court says no, because of the violation of a fundamental right, a right to be heard. The re-collation of the results cannot be allowed to stand. What happens with the Gazette? Does it operate? I didn't hear any consequential order. Does it operate to nullify the Gazette? If the
I
court
thought that's clear on its face.
Well, that's
because the court is supposed to hear. Because there's been a quashing order, quashing the orders that allowed that to happen. So it doesn't exist anymore.
So it doesn't exist.
So we are back to the status quo.
Where those
NDC MPs had been, however, declared as winners.
So if the court hears the Bandamu's application,
yes,
and goes ahead to say, look, we don't think that, because duress is a question of fact, and
right,
that has been stated severally by you. If they don't see duress and cannot compel the Electoral Commission to do otherwise, then the Electoral Commission will have to gazette the seven MPs who are now...
So it's possible that at the end of the day, the new order, potentially on Tuesday, will lead to a re-collation again.
It's possible.
Okay. Yes, Oliver, what will be your concluding comments on particularly going forward and resolving this?
I mean, I think that we are going to be in this for a very long time. I don't think that what happens in court on Tuesday is going to resolve anything, and that the other issues will come up right after whatever court decides. But one of the things I want to bring emphasis on is the reason why we are in this situation. In the last election petition, this very issue has to questioning or interrogating the work of the elections manager and electoral commission came up, and the electoral commission was shielded from scrutiny. And the resolve or the understanding then everybody got away from what happened was that elections are won at the polling stations. My view then was that that was dangerous for our democracy, and that it would lead to precisely what we saw happen in this election, that the parties then feel that unless we get our supporters to mass up at polling stations, the elections are going to be stolen from us and would have no recourse. It is not good for our democracy that we make participants in the elections feel that it is up to them to secure the integrity of our elections. This is why we are here. Now, unless we can resolve that question, unless people can have greater confidence, one, in the EC, and feeling that, well, whatever happens, we can go to get court and get an expeditious decision, they need to hijack the process or to mass up at the polling stations will not dissipate. And finally, we cannot emphasize enough the need for the EC to be consistent in the way in which it applies law. Because you cannot continue to continuously change your positions. And if you do that, you will diminish integrity or belief or trust in the process. And we are continuously going to be involved in this situation that I think Honorable describes correctly as a constitutional crisis. That's my last word on that.
All right, thank you. So, Honorable Ikoyotu.
Yes.
So, we have a resolution. We have a resolution, don't we?
I think that the undue vilification of the EC is uncalled for. As we have all agreed on this platform, we are all lawyers, that there are laws by which they act, and therefore we can only fault them if they are doing things against the law. This whole idea of they doing a re-collation without inviting the other side is not true. They were all invited to come and to bring whatever pink sheets, as we used to call them, are available for the collation to be made. The important thing is that it's not necessarily due to they proving any intimidation, but the fact that the coalition did not end before declarations were made. And so we know that there were about 31, and other places there were more than that, which had not been collated. Why should we then rush? And I'm happy that Vamavo talks about this massing up. I have spoken about it. Things were going fine until somebody called on supporters to go and mass up at the pollution centers, and then all the confusion, then arose. So why don't we allow the EC to do its work? In all places where we did not have difficulty, the coalition was done. Why is it that in certain places we went and created a mess And all the EC says that bring us the pinches and let us collect everything once and for all in the presence of your own representatives. That was what was done. They were all invited to bring whatever documents they have for the coalition. It was done, please. For example, this talk about Dr. Bosman having said something. We are here talking about the right to be heard. I don't think that he's been given the right to be heard. So let us go slow on some of those things and allow the EC. I mean, the democracy is growing. At a point, if you recall something, they came and gave money and said, if you don't vote, you are going to die. After some time, the people say, you lie bad, we'll chop your money and still vote against you. That is how the democracy and things, we are growing as a nation. And so some of these difficulties will come here and there, but allow the systems to work.
Right.
Allow the system to work instead of always vilifying them.
All right. Clara, your final comments, and Kweku asks questions. So are we being told that a constitutional body, in this case, the EC, should not ensure its officers and its processes follow the law governing their functions, and that the commission is stopped from taking any administrative action when its officers report that they were prevented from following the law in the conduct of their functions? To Clara, why should a body not have the capacity to determine their capacity? They can't read their governing law. Should every decision of a constitutional body be referred to the courts?
No, but the question is not, what I said was that when you declare an illegality, there's an issue as to whether you have capacity to declare an illegality.
That's right.
Now, we have to differentiate between collation and re-collation. Is the case being made that collation was not completed, and so we are completing collation? That is completely different. Nobody can stop the EC from collating. They're two completely different things. So if the EC is saying that collation was not completed and we are completing collation, I think that is completely understandable. Now, it is a different thing if the EC says that collation was completed. However, upon second thought, we have decided that the completed collation is illegal. And so we are going to do re-collation. The reason is because the same EC has rules governing re-collation. Now, the second question is, what do those rules say? So it is not mere illegality. It is what I think that if the EC is saying that we are not done with collation, I don't have a problem with that.
I think there's no argument about that.
Exactly. So it is if you say you are doing re-collation, what do your rules say about re-collation? And it's one, so you will have to comply with your rules. Now, we must acknowledge that generally in life and in a society, there always comes a time where something may happen that your rules did not anticipate. And when that happens and your rules have not anticipated, your best bet is the rules of natural justice. So at that time, you will have to do something. You can't throw up your hands in the air. But I think as an administrative body, you will do something, and you will do right if you just comply by the basic rules of being fair.
Don't let Kweku's question take over your final comment.
Yes, it's being fair, candid, and impartial to all parties. So, but that actually ties into my final comment, that the EC, we have to admit, has not enjoyed a lot of credibility going into the elections. And it hasn't been new in our democracy. It is the more reason why I think that the EC must really, really work hard to make things very transparent. If there was a lot of transparency and people can follow what is going on, I don't think there will be the need for people to mass up at the collation centers. We can't, I think we were running away from the issue if we just tell people that don't mass up at the collation centers. The question is, why do people mass up at the collation centers?
Suspicions of cheating.
And what ends the suspicions? Transparency. So I just think that there should, if we can work more, especially in this digital age, to make things very easy for people to follow and for people to see that the EC has no interest in the election. The EC is not contesting the elections, but the EC does have an obligation to conduct its affairs in a certain way that is beyond disrepute.
Thank you very much. And this is Newsfile. It's your most authoritative news analysis platform. We'll go into the second segment shortly, and this segment has to do with the Constitution. Honorable News Afseni has been referring to it as the GRU norm, right? What is happening to the Constitution? In 2010, Professor Mills asked for a Constitutional Review Commission. They did their work, presented their report in 2012, and there were processes to ensure that those were done, they were not done. There was a court case that eventually took us a couple of years down. And today, there is a new report that has been sent to the president, and the president has given the assurance that he will submit it to President Mahama, and together with his own notes, including especially that there must be comprehensive public buy-in before a process to implementing the recommendations. Remember, this is the committee that says cap ministers at 25. 25 ministers is all that we need in this country. Bawumia was promising 50, and John Mahama is going to do 60 because that was his promise. They also were proposing the expunging of deputy ministers as well as the scrapping of regional ministers completely, among other important issues as far as the Constitution is concerned. We take a break. We'll be right back, and Oseche Mensah-Bonsu joins us. This show is brought to you by Bank of Africa, strongest group and closest partner, MTN everywhere you go. Ashesi University, educating ethical and entrepreneurial leaders for Africa. Robert & Sons Optical Services, your comprehensive eye care service provider for 33 plus years. My Way Insurance, simply dial *165# on MTN to join My Way today. DB Industries, roofing Papa Fie. Flamingo Paints, simply superior. Syntex Tanks, it's strong, it's tough. Activa International Insurance, our clients, our passion. When we return, Clara will give us a peek into what the committee has come up with. And then Oseche Mensah-Bonsu will tell us the process and the importance of this, why it has not been left. We'll be right back.
Yes, it's been gazetted.
It's been gazetted.
It's been submitted to
Parliament.
Thank you.
Today.
Not today.
No, not today.
The 274 has been gazetted and presented.
Those places are Re-collation. They are saying
So you
that
can go to the
their
Ghana
officers
Publishing Company for a copy.